Welcome to Gracefully Graying. I'm your host, Attorney Henry Gornbein. Today on Gracefully Graying, I am very pleased to welcome as our guest Amanda Gardner of the Schluter Hughes Law Firm as she leads us on the topic of love plus clarity plus fairness in estate planning. Interesting, and I guess we'll be exploring this in detail. Amanda, welcome. First of all, why don't you tell our viewers a little bit about who you are and your background?
Hi, Henry. I graduated from Detroit Mercy School of Law. Before I became an attorney, I was a paralegal for about 5 years. I worked for a solo practitioner, so it was just him and I. So I gained a lot of great hands-on experience working in an estate planning firm, which I definitely think, allowed me to become a better attorney once I got my license. I also took the Florida bar exam, so I'm licensed to practice in Florida as well.
That's quite an accomplishment because I know
Thank you.
Florida is very difficult and because everyone wants to use Florida as a kind of semi-retirement and they really don't want it.
Yes.
So congratulations.
Yep, I flew down there and it was an ordeal, but I'm glad that I did it.
Great. Amanda, what are you specializing in with the Schluter Hughes Law Firm?
So at our firm, we primarily focus on estate planning, trust administration. We also do family law, guardianships, and conservatorships. I serve as court-appointed counsel and as a guardian ad litem in Macomb County. So I serve for individuals who don't have their own attorney. They can't retain one on their own. So I serve for them in guardianship and conservatorship proceedings. I also serve for what we call the developmentally disabled docket. So I'll represent those developmentally disabled adults as their counsel to kind of walk them through the process of the proceedings, which can be tough. But we also have two care coordinators on staff at our firm. So we have an RN and a PA who I work with closely with a lot of our clients who need the care coordination aspect as well.
Fascinating. Tell us about some of the data regarding blended families. I know in this country we have a very high divorce rate, and my specialty happened to have been family law over the years, so I'm very familiar with it. But give us some of the data.
So we do have quite a few blended families here in the United States. The U.S. Census data for 2024 tells us that about 40% of American families are blended, and every day about 1,300 new step families are formed. And the research also tells us that marriages that involve children from a previous marriage are more likely to fail than those marriages who don't have children from a previous marriage. So the data definitely tells us that blended families are very prevalent, and I think that there's not a lot of work going on behind the scenes to make these marriages successful, which is what we try to do here at our firm.
You know, it's true. It's challenging because, the wicked stepfather, wicked stepmother, all these fairy tales, often there's some truth to it. And also often there are alliances with stepchildren wanting to have very little to do with their new step parent, whether it's stepfather or stepmother. So it's challenging. Why is estate planning different with blended families, Amanda?
So, drafting an estate plan to begin with can be difficult. It involves, asking the hard questions. I get people who tell me sometimes, "Oh, I don't want to do estate planning because I'll be gone and it doesn't matter to me what happens," or "I just don't want to think about that kind of thing. I don't want to talk about my death." It's scary. It brings up feelings that maybe are uncomfortable. And if we add in the aspect of a blended family with a new spouse, how they interact with your children, how you interact with their children, it can create an added layer of complexity. We when we're making an estate plan, it's very important decisions being decided. Who's going to make medical decisions for you if you can't, if you're incapacitated, you have to trust someone to make that decision for you. Same thing on the financial side. You're appointing someone who can make financial decisions for you, you know, your whole life's legacy. They can make decisions about your money. It's an uncomfortable feeling. And when you have a blended family and a new spouse, those decisions can be made a little bit more difficult. And depending on the situation, sometimes couples want to keep everything separate. They say, what's mine is mine, what's yours is yours, never shall they meet, which sounds great, but sometimes that's not always practical. A situation that comes to mind is, what if one spouse needs a higher level of care? They're getting older and they need caregivers, or they need, more medical attention, but they don't have the finances to pay for that. But the other spouse does. Up until this point, we've kept our assets separate. You've paid your bills, I've paid mine. Is it the responsibility of that second spouse to pay for the higher level of care for the first spouse? Those are questions that we like to ask before it gets to that point, because sometimes once someone's at that level, that decision can be made way more difficult by children from both, sides of the field coming to play when it comes to those kind of decisions.
Those are tough issues, and it brings to mind a situation I was involved with a number of years ago where it was a short-term second marriage, and the husband was actually an attorney, and he started developing early stages of dementia, could no longer practice, and needless to say, the wife divorced him, and it was a very sad situation. Again, there were finances enough to take care of each other, but this was a situation where she just didn't want the commitment. So you have all kinds of scenarios, and again, in second marriages, it's more difficult. How do you reduce ambiguity so your loved ones do not end up in conflict?
That's a great point, because like we talked about, sometimes these decisions or these conversations aren't comfortable to have, but they're so important to have, because if you're marrying someone, you're expecting till death do we part, right? Sickness and health. And like your example stated, sometimes that's not always the case. So, you might assume one thing. You might assume, oh, my spouse will take care of me no matter what. They love me. They will go to the ends of the earth to take care of me. And that might not be the reality of it. So taking that ambiguity out, can be a great first step in avoiding conflict, especially when someone's sick or someone has, Alzheimer's or dementia, and, tensions are already high. Getting your estate planning documents drafted and executed is very important, but also there needs to be a conversation had with those documents. So sometimes clients will leave, they've got their beautiful binder with all their documents, and they put it in their office, and there it sits, for years and years until they're needed. And the conversations are never had. So I always like to tell my clients before they leave, especially if it's a blended family situation, to have a conversation about the documents. Don't just put them on the shelf and leave them for the next 20 years. I always ask them, okay, you've nominated your son or your daughter to act as your patient advocate or your power of attorney, but do they know that you've appointed them? Does your spouse's children know that she's appointed them? Or maybe it's a situation where you get along better with your spouse's kids than your own kids, so you've appointed them. Do your kids have any idea that that's what's going on? Also, you want to make sure there's no ambiguity to what your ultimate goals are. If you're nominating someone to act as your patient advocate to make medical decisions for you, do they know what your medical wishes are? Do they know, do you want a living will? Do you want artificial hydration or nutrition? What are your ultimate wishes, so they don't have to do guesswork, because guesswork leads to fighting. If the decision has to be made by one person, of course, as we all know, they're going to get the input from the peanut gallery. Everyone thinks that, oh, well, I know mom best, or I know dad best, and I know this is what they would have wanted, which leads to fighting. And we want to avoid that fighting. So having the conversation ahead of time can help reduce some of that ambiguity.
And these are tough conversations. I mean,
They are.
have to think about the future, whether it's death, whether it's an illness. So these are tough conversations. How do you protect your new spouse while also considering your children, Amanda?
So this is super important when someone remarries. So usually it's later in life. They often bring two priorities. I want my spouse to be secure if something happens to me, if I pass away or I become incapacitated, but I also want to make sure my children and my grandchildren maybe are taken care of as well. And these two goals, they can absolutely coexist. It just takes a little bit of work to get there. The thing that we want to avoid most is, oh, I trust my spouse, or I trust my daughter to do the right thing. because as we know, sometimes that does not always work out. We want things, written down and in writing and very clearly communicated to everyone, so we don't run into a situation where we're relying on the good faith of maybe a new spouse that your children have never gotten along with, but you didn't realize that because everyone did a great job of pretending, right? So we want to protect everyone involved, and it really just depends on the goals and the wishes of the client getting the estate planning done. Like I said earlier, sometimes people come in and they say, oh, well, everything will just be kept separate, so we're not going to have any issues. But that isn't always practical. So we want to make sure that we explore all the options in your estate planning to help you achieve both goals of protecting your new spouse while also keeping your children and your grandchildren, if applicable, in mind.
Amanda, what about communication between families? And this can be difficult, especially if you have families who are scattered all over the country, which is more and more common, especially in a blended situation. So how do you handle some of that?
Yeah, that's a great point. As we get to the modern world, sometimes we have people who have families that live in other countries, let alone other states, and communication can be tough. I come from a very traditional Irish family where, feelings maybe not talked about as much and everyone just kind of puts their head down and everything's great. So I can understand the apprehension to bringing out all these feelings. And sometimes it's easier to just stick them away in the closet and say, oh, well, everything will be fine. We don't have to talk about it. I'm not worried. That's not the greatest strategy when it comes to, avoiding problems. So communication is definitely key. Sometimes I tell my clients, think of it as the family business. This is your board meeting. Everyone sits down. We talk about what's going on and we get everything out in the open, because there's nothing worse than feeling blindsided or feeling like you thought one thing was true when really in reality another thing was true. So I run into that situation a lot where, one spouse passes away and the other spouse says, oh, well, he told me, I would be taken care of. And in their head, taken care of means one thing, but in reality, that thing was not true. Or it was, oh, I thought I was getting the house once my spouse passed away, but that wasn't true. Then they feel blindsided, and that can create, a whole plethora of problems. So the communication beforehand could have helped avoid those problems. So I think of it as have your board meeting. Sometimes, especially in blended families, they're later in life. If both parties have children, those children are often adults. Sometimes they have their own children by that point, and everyone's busy. We all understand that. Everyone has their own lives going on, and sometimes no one has time to sit down and talk about these issues, but it can be crucial to sit down and have your meeting just so everyone has clear expectations. You don't want anyone to ever feel blindsided and feel like, they were left out, because when someone starts feeling like that, that's when things can really go downhill. So it's always our goal to just make sure everyone knows the goals, how to achieve those goals, and, how things are going to play out in the case of death or incapacity.
Amanda, transparency is critical, but what I'm thinking about now, it's almost as if you need several meetings. I mean, first of all, it seems like you need a meeting between, well, husband and wife who are doing the estate plan to make sure they're on the same page. But then it seems you have to bring in others, children, perhaps grandchildren, stepchildren, who are all going to be affected. I mean, are there going to be multiple meetings? Tell me your thoughts on that.
So it definitely can be a multiple step process. I think first and foremost, you always want to have the open communication with your spouse or your future spouse if you're not married yet, because, I think as we all know, finances can be one of the leading causes of divorce in this country. And we want to make sure we have those conversations ahead of time and sit down with your spouse and say, what are your goals? Who do you want to take care of in your trust? And, what are your medical, thoughts and feelings about what might happen to you? And just get those conversations out in the open so that, there's no problem that we can't fix here with your estate plan, but sometimes we don't know what those problems are until that conversation is had. So that can definitely be the first step. Sometimes I have clients who come in and they've talked about nothing. They don't have any idea of who they want to appoint, how they want things to be divided once they pass. But I can kind of help walk through those questions. And here I know sometimes I'll have 3 or 4 meetings with a client before we ever even execute a document, because those conversations are important. I always think of, your mission statement. What's your mission statement here with your assets or your, livelihood? How do you want things to go? So that's definitely a great first step. I think the conversation with your children or possibly your grandchildren, the most important is the people who are appointed to be in charge as your trustee or your power of attorney. You want to make sure they know that they're appointed, because I have that come up a lot too, where, it's a second marriage and the wife's son is an attorney or a CPA. So naturally they appoint him to be the trustee, but he doesn't know. And the other spouse's kids don't know. So they're thinking, well, wait a minute, why is he appointed over me? When in reality, the answer was simple. Oh, he's a CPA. He was the best person for the job. So if you have that conversation ahead of time, that can create so many less problems, because everyone's like, oh yeah, that makes sense. John is a CPA. Of course they would appoint him as the trustee. But without that conversation, no one would have known that, right? They don't know those intentions. They might think, oh, well, they like him better than me, so that's why they appointed him, which might not be true.
Brings to mind another thought, and that is often you have different ideas, especially since you do a lot with regard to guardianships and disability situations. Uh, one spouse or one family member might say, well, I want to age in place no matter what. And another might say, well, I'd rather go into a senior residence, or perhaps it's time for assisted living. How do you ferret through some of those issues?
It's a great point, and that situation does come up where, and I've experienced it as well, where one spouse has to move into a higher level of care. They need to be in an assisted living facility, but the other spouse doesn't, and they want to stay at home. So those are conversations that, can't be had once the spouse is at that point where they have to go into the assisted living. Sometimes if someone doesn't have capacity, say they have, early onset dementia or something like that, and then the conversation can't be had. But if we have it earlier, then we can put resources in place. We can come up with, sometimes people pre-plan. They pick out exactly where they want to live. They say, this is the spot for me. They budget it. Sometimes I work with advisors where they can come up with, a 20-year plan or a 30-year plan to make sure that the finances are there to afford that assisted living facility. So if we never open the door to have that conversation, we can't come up with the solutions. So like I said, there's no problem we can't solve. It's just a matter of identifying what those problems are. So say one spouse does want to age in place, we can make sure that there's resources allocated if possible to keep them there, and make sure that there's, fairness in the division of the assets to make sure everyone gets what they want.
Let's talk about prenups. How important are there for prenups for second or third marriages?
So I think that a prenuptial agreement becomes even more important in a second or a third marriage, because usually these are later in life. And as we get later in life, more assets are accumulated. You have maybe your retirement accounts, or you have real estate and you have more equity. So the prenuptial agreement becomes even more important. In a first marriage, maybe you're in your 20s, nobody has any money. There's no need for the prenuptial agreement because there's nothing to divide, right? But that's not always the case for these later in life marriages where children or possibly grandchildren are involved. It's definitely a tool in our toolbox. And I like to tell people it's not created in anticipation of divorce, but really just to provide clarity and protection for all the parties involved. By the time someone remarries, they might not have as much faith in the marriage system, right? So they say, yeah, I want to have a prenup. And it doesn't mean that you think you're going to get divorced. It doesn't mean you don't have faith in your marriage. It's just going to help avoid some of the problems in a divorce proceeding. As I'm sure specializing in family law, sometimes those divorce proceedings can become very heated, and they can, ruin long-lasting relationships. The prenuptial agreement, it's kind of taboo. People always kind of roll their eyes at it, but I always think if there's something that you can put in place to ensure that your assets are divided fairly, and fairly doesn't always mean equal, but it just means fairly, the prenuptial agreement can help accomplish that. I'm getting married in August, so I can tell you from experience, it's a lot easier to have a conversation about a prenup when you're in love and you're getting married and everything is great and you can have, a cool-headed conversation about it rather than later when you're in a divorce and everyone is hating each other and, no one's getting along. It's definitely a better option to get the prenup. That way it's in place. You can always revisit it and make an amendment to it, a postnuptial amendment later, but just have that in place. It's another tool to just make sure that everything goes according to plan. Because as you know, sometimes in the divorce proceedings, if there is no prenup, it can get pretty messy.
I think for our viewers, it's important to explain exactly what a prenup is, and I'll digress a little bit. And a prenup is an agreement that's signed prior to a marriage. It's usually witnessed. It's better to have two attorneys, and it lays out what is to happen in the event of divorce, but as well as in the event of death. And one of the main purposes, especially, is to protect not only a spouse, but also the children from prior marriages. So it's an important time to lay out exactly what your wishes are in the event of divorce or death. And it's important to usually tie these in with the estate planning documents as well.
Absolutely.
Amanda, what are some estate planning strategies that you would recommend
So I
for our
always
viewers?
recommend that everyone have estate planning, of course. It's not the most fun thing to talk about, and saying, "Oh, I'm going to the lawyer's office" isn't the idea of, a fun day out. But, depending on your family situation, your family dynamic, your goals, expectations, as well as your assets and what your financial situation is, there's a whole toolkit of strategies that we have available to use. Sometimes clients will come in with the problem, or they'll come in with goals, and I'll say, oh yeah, we can achieve that by doing a joint trust or a separate trust, or we can create a pooled trust for the benefit of all the grandchildren. And they look at me like, oh my gosh, we had no idea that we could do all that, and we can. So there's plenty of options for whatever your goals have in mind. Another thing, especially with a blended family, is the patient advocate is crucial, because as we know, things come out of nowhere. Everyone is one day away from getting in an accident or having an unexpected stroke or heart attack. And then all of a sudden you're in a situation where you don't have capacity to make your medical decisions anymore. And that's a very intimate and very important decision that has to be made. So maybe you don't want your spouse to be the person in charge, or maybe you don't want your kids. Maybe you'd rather have your spouse. So those medical decisions are very hard decisions to make. And getting the patient advocate designation, especially if it's a second marriage and there's children involved, I think is one of the most crucial, just to make sure that and the situation comes about where someone's making medical choices for you about where you're going to live or what kind of treatments you're receiving, you want it written down and you want it well known who that person is, and you want to express your wishes to them ahead of time so they know what they are.
I think one of the most important things of a patient advocate is deciding what type of end of life strategies are there. Is there to be resuscitation? Are you to use everything medically possible, or is someone to be allowed to just go naturally? And again, Amanda, often there are disagreements among family members over how to handle this. So is this something you
Absolutely.
try and discuss in advance? How do you handle this?
Yeah, it can be a not so fun conversation to have. I've had this conversation with my own mom, and we all say here in the estate planning world, if we had $1 for every time a family came to us and said, "Oh, don't worry about us. We all get along." Yeah, well, everyone gets along when there's no issues, but it can be a tough conversation to have, but sometimes it just needs to be had. Do you want us to keep you alive on the ventilator? Or do you want the artificial hydration? What is it that you want? Because if you don't decide now, we have to decide for you. And that can be a burden on someone to have to make that decision. I always say, estate planning is an act of love. It's a gift to your loved ones to make those decisions ahead of time and have your estate planning done, because they don't have to make that decision for you. And serving as a guardian ad litem for the probate court, that's a guardian ad litem is like a neutral third party. You're kind of the eyes and the ears for the judge. You interview all the interested parties. Usually it's when someone is seeking a guardianship or conservatorship over someone. And I have seen more times than I can count 3 or 4 siblings that are all in disagreement, and they all tell me the same thing. Well, I knew mom best, and I know what mom would have wanted because mom now has dementia or mom's in a coma and she can't make those choices. And all 4 of the kids have a different idea of what mom wanted. And if the person has no planning, who are we to know what the right decision is? So at the end of the day, now the judge is making the decision. So do you want, your end of life decision made by a judge who you've never met? Probably not, right? And do you want to create a rift between your children about having to make that decision? No. So while it's uncomfortable, I told my mom this because she was the same. She said, "Well, I just don't want to think about it." I said, "Well, you have to think about it. And then once you're done thinking about it, we'll put it in writing and then we're done with it." So it's not the most fun thing to do, but it's very important. And it really is a gift to your kids and your spouse to make those choices.
Let's circle back. The topic is love plus clarity plus fairness in estate planning. So really, we've covered the fact that love is very important. Clarity and transparency is critical so that people don't make mistakes or to avoid conflict later on. And fairness, and everyone has a different version of fair, and it's a matter of coming up with the best solution. Amanda, what are some final thoughts you would like to share with our viewers before we sign off?
I think, whether it's your first marriage or your third marriage, or you have, 10 children together, 0 children together, having conversations with those that you love, that are in your life, about what you want done, about your expectations, your goals. I think it's just one of the most important things that you can do. Blended families, they don't have to be complicated. It's just layered. And, with the right estate planning attorney, you can navigate those layers thoughtfully, intentionally, and come up with an end result that makes everyone happy at the end of the day.
So there are a lot of tools in your toolbox, and Amanda Gardner of Schluter Hughes, I want to thank you so much for being our guest on Gracefully Graying.
Thank you for having me.
It's been a pleasure, and you've covered a very important topic in a very thoughtful and meaningful manner. And I want to thank our viewers, of course, and of course our sponsors and Bloomfield Cable for making this possible. Thank you again.